Welcome members to today's discussion. My name is Dominic Mutunga from School of Law, and today we are going to discuss about medical negligence or clinical negligence, which is under medical law and ethics. The code is 2207, and we are ready to start with the chapter. Welcome. Members, in today's discussion, we'll be able to focus on the clinical negligence, or what we call medical negligence. And what you need to understand about negligence is where a medical practitioner or a doctor falls below the expected standards of medical practice. Remember, in our last discussion, we said that medical law and ethics is aimed at promoting good standards within the medical practice in our society. And that means that where a doctor or medical practitioner falls below that expected standards, then that means that is below the expectations of that medical practice. And possibly what happens that if the expected standards are below the expectations of the society, and from the practice of that medical practitioner or doctor, there is an injury or harm to the patient, then of course that involves an issue of negligence. And secondly, we need to understand what are the salient elements of negligence. Members, you need to understand that we have three important elements of negligence. And the first one is what we call the duty of care. So you must, for negligence to occur, the first test that must be satisfied is the duty of care. The second one is the breach of that duty of care. And of course, the third element, or the third salient element, is from the breach there is loss or damage. So members, it's very important to appreciate those three salient elements of negligence. And you also need to, as we start with the first element about the duty of care. When you talk about this duty of care, you need to understand that a medical practitioner or a doctor must always exercise reasonable care, skill, and diligence. Because remember, just like any other professional, the standards expected of a professional are higher than that of an ordinary person, or other than that of a lay person. And therefore, that duty of care must be owed to a patient. Remember, this duty of care is owed to a patient. But of course, we'll be able to discuss about the exceptions whereby the duty of care can still be owed to third parties. So members, in this case, you need to understand that this duty of care is basically owed to the patient. Then, and still under that, you need to understand, when you talk about this patient, remember under the case of Donoghue versus Stevenson, the case of Donoghue versus Stevenson, the case was about, or the case enunciated about who is a neighbor, because it is from that understanding you will be able to connect between this neighbor and the patient to whom a doctor or a medical practitioner owes a duty to. And in this case, remember, under the case of Donoghue versus Stevenson, Lord Atkin basic or instructively defined who a neighbor is. And from the Lord Atkin's world, a neighbor is that person who is directly or indirectly affected by your acts or omissions, and you ought to have them in contemplation. So in this, that means that a neighbor is that person who is directly affected or indirectly affected by your acts or by your omissions, and you ought to have them in contemplation, meaning that there is a test of foreseeability under this neighbor principle. And that case has been amplified further through the case of Caparo Industries PLC versus Dickman, because it is from this Caparo Industries PLC versus Dickman that three broad tests were enunciated. And the first test to be able to discern whether there is a duty of care or not, the first test is whether it was reasonably foreseeable that damage would be caused to the plaintiff by the defendant. That is the first test, whether it was reasonably foreseeable that damage would be caused to the plaintiff by the defendant. That is one. The second test is whether there was a relationship between the plaintiff and the defendant, and whether that relationship was of reasonable proximate. That is now the second test that you need to discern. Then the third test is whether is it fair, just, and reasonable to apportion blame, or to be able to apportion blame on the defendant. Having satisfied the first and the second test, then the third question that we are asking ourselves is it fair, is it just, is it reasonable to apportion blame on the defendant for what he has done to that patient. So members, you can be able to see those two very key cases. The first case is the case of Donoghue versus Stevenson, and the second case being the case of Caparo Industries PLC versus Dickman. So once you understand that, then you can comfortably say that this duty of care should be owed to the patient. And from that, then you can be able to see there is nexus between the patient who is either directly affected by the acts of who is directly or indirectly affected by the acts of the doctor or by the acts of that medical practitioner. Of course, it's also very important to be able to discuss about from the breach to the loss or damage. There is also an aspect of causation. And when you talk about this causation, this is where we look at the flow of events, how the events, how the acts were able to flow for this damage or loss to occur. And you also need to understand where we have that flow of acts or the flow of events, then in that case, we talk about the chain of causation. And in that respect, members, we look at whether that chain of causation has been broken or not. If members, what you need to understand that if that chain of causation is unbroken, or it flows from point A to point B unbroken, then it means that the defendant's acts will be the likely cause of the damage or loss to the victim or to the patient. And therefore, it's very important for you members to be able to understand where this chain of causation and to what point this chain of causation is broken. And once you appreciate that, then you will be able to know it is defendant X who caused, for example, the death of victim Y. Because from that respect, then the chain of causation was not broken. But where we have an intervening event, or what we call novus actus interveniens, is where the chain of causation is broken at a point. And where that chain of causation is broken at a point, then we'll be able to see who was the likely cause of the damage or loss to the victim or to the patient. So in this case, possibly will be confounded with two events which have happened. And in this case, we'll be asking, is it defendant Y or is it defendant X who is the cause or is the major cause of the loss or damage to the victim or to the neighbor or to the patient in this case. So it's very important, members, to be able to appreciate from those salient elements of negligence what happened. The first is the duty of care must be there, the breach and the loss. And then remember about the chain of causation. And it's also from that point, and remember the case of R versus Blue, the case of R versus Blau, where a girl who was who received several stabs by a boyfriend, by her refusing to have sex with him, and as a result, this the girl, being a Jehovah's Witness, refused to have blood transfusion. And from that respect, the question was, who really caused the death of that young girl? Is it by her refusing to have the blood transfusion, or is it as a result of boyfriend's stabbing? And the court was of the opinion that this the stabbing caused the fatal wounds, and therefore it is not about the girl refusing to have blood transfusion. The death of the girl was caused by the boyfriend's stabbing, whereby fatal wounds resulted from that stabbing. And therefore, you can be able to see, for the court, the chain of causation was not broken at that point, and therefore the NOFA's actors intervenience, that is the refusal of blood transfusion, did not affect the chain of causation or the flow of the flow of causation in that respect. And of course, you need to understand the law is very clear that you leave the victim as you find him. Remember the thin skull rule. Leave the victim as you find him or her. And therefore, it means in that respect, whether this girl was a Jehovah's Witness or not, leave the victim as you found him or her. So that is basically what you need to note, members. And as I said, in this respect, we say that the duty of care is not basically all to strangers, but I say that this duty of care is all to the patient. And we also need to understand who is this patient. And this patient is well defined in the case of Burnett versus Chelsea and Kensington Hospital Management Committee. And it is from this case that the court was able to rule that a duty of care is all to that person who as he walks to the door of the hospital, becomes a patient. That is through that case of Burnett, of who a patient is. So for someone to become a patient, once you enter into an hospital door and the doctor records the clinical notes, then in that case you become a patient. And in that case, a relationship is created between that doctor or that medical practitioner and the patient. And we remember, we say that where we have a relationship, it must be of proximate, it must be of reasonable proximate. Because when it is too remote, then you cannot be able to apportion any blame on the defendant, or you cannot be able to apportion any blame on that party who falls below the expected standards. So there must be a special relationship, members, between a doctor and a patient, or between a medical practitioner and a patient. But members, I say that we also have exceptions to that. So in this, and remember the case of Kent versus London Ambulance Service. Then we have exceptions where a duty of care is not necessarily to the patient. It can still be all to a third party. But remember, that is the general rule, is that this duty of care is all to a patient. And remember, we say that where we have a duty of care, then we have where we have the general the general proposition, then we also have exceptions to that effect. And therefore, in this case, we have exceptions. And the first exception is where we have the disclosure of infectious disease, like what is happening in our country, where we have COVID-19. the duty of care is not being owed to the patient alone. Every day we receive briefings from the Minister of Health, and that is it is because the disease is so infectious, and therefore you can be able to see this duty of care is not only to the patient but also to the third parties, because the public in this case becomes the third parties, and therefore that is one of the exceptions that you need to note. But you also need to note, still under that, if you look at the case of Palmer versus TSHA, you also need to understand this third party must be an identifiable party. It cannot be to the general world. It should be to an identified party. And therefore, in this respect, then in as much as the duty of care can be owed to the third parties must be identified or identifiable. And therefore, in this respect, it is not a duty being held to the whole world. It must be to an identified entities. Then the second exception, members, is about the rescuers. And in this case, you need to look at the case of Umbanitsky versus Patel, where the father of a daughter donated his kidney to be able to save the life of his daughter. And in this case, or in this respect, then you need to understand that the doctors were negligent because they did not diagnose whether the kidney was compatible with body system, because in that case of Umbanitsky versus Patel, the kidney failed, and therefore this doctor, the medical practitioner, was held to be negligent. Then we also have another exception, is about antenatal injury, and this happens where a fetus is injured, and in this case you can be able to see the mother being the primary patient. That duty now moves from the mother to this fetus, and you can be able to see where injury is caused to that fetus. Then the doctor or the medical practitioner in that case is held to have been negligent. And look at the case of Barton versus Islington Health Authority. Then we also have the case of psychiatric injury suffered by a third party, and we have a very seminal case, the case of Alcock versus Chief Constable of South Yorkshire. And this is where the third parties can be able to sustain a claim in as much as they were not the primary victims. And in this case, we have primary, remember we talk about primary victims and secondary victims, and you can be able to see, like in this case, we are talking about the primary, the secondary victims. And we have this case of Alcock versus Chief Constable of South Yorkshire. Remember also the case of Boyle versus Young. So those are some of the cases that you members, you need to really understand. Then the final exception under the duty of care is what we call assisted conception. And still under that, where we have assisted conception, a child born out of that process, and maybe there is injury or deformity on the part of that fetus, then in that case, the doctor is held negligent for that assisted conception. So basically, members, that is the first test that you need to appreciate, the test of the duty of care. Let's now look at the breach of duty, because as I said, where the doctor or medical practitioner falls below that expected standard of medical practice within a society, then that is basically a breach. And in this case, you need to look at the case of Bolam, then, because we call it a Bolam test. And from this Bolam test, we need to understand how a doctor or how a medical practitioner is held negligent. And because the court is not an expert in medical science, or the lawyers prosecuting the case, then in this case we call another body of responsible persons to be able to give what we call an expert opinion. And this expert opinion will be able to unearth whether a doctor or medical practitioner was negligent or not. And members, what you need to understand is that in as much as that medical opinion is offered by another responsible body of men, you also need to understand that expert opinion is basically a matter of fact, meaning that in as much as the doctor or that expert will be able to give an expert opinion, that will not be final. The court will be able to make the final determination whether that doctor or that medical practitioner was negligent or not. So you need to understand, even in as much as we invite this responsible body of men to be able to give an expert opinion on the cases of negligence, then it's very important for you to understand that the final determination rests with the court, and that is because the court will be able to make the final pronouncement. So in this case, of course, the court will be so much inclined to that expert opinion. But remember that expert, that body of opinion or that expert opinion must be responsible, because if it is not responsible, then it means that the court will not be moved and the court will not be inclined to follow that expert opinion. So it's very important, members, under that case of Bolam versus Frian Hospital Management Committee, you need to really interrogate that case, and you'll be able to understand how the doctors are held, how the doctors or the medical practitioners are held negligent. And it's also very important to be able to understand what is the standard of the standard, because the standard of proof is on a balance of probability. So in this case, you need to understand the standard of proof is basically on a balance of probability, not beyond any reasonable doubt. So in this case, the claimant will be able to prove his or her case on a balance of probabilities, and it's very important to be able to understand about. Then you also need to understand what is the standard of care. The standard of care expected of a medical practitioner or a medical doctor. And in this case, the standard of care expected of a doctor or a medical practitioner is of that ordinary skilled person. It should not be a higher standard. It is just a standard of an ordinary skilled person. And therefore, you need to understand, of course, it will be higher than that ordinary lay person, but it is equal to that other professional person in the circumstances, because we are looking at ordinary skilled person, and therefore it is not a higher test, but it is a test for another person who possesses a special skill. So in this case, that is what you need to note. And look at the case of White House versus Jordan. Look at the case of Maynard versus Midlands RHA, and look at the case of Sindway versus Bethlehem Royal Hospital Governors. So basically, we have discussed about the proof of breach, and I have said that it is on a balance of probabilities, and it's very important to understand how that happens. And we have a very special case, the case of Ark versus Cole. Lord Denning, a Master of Laws, said that a charge of negligence against a medical person stands on a very different footing from a charge of negligence against a motorist or employer. So in that case, you can be able to see the standard of care is higher compared to that of ordinary person or ordinary lay person, because you can be able to see Lord Denning saying that charge of negligence for a medical practitioner is higher compared to that of an ordinary person. And he gave an example of a motorist or an employer. And he said that the reason for that, the reason why the charge is higher or the standard of care is higher compared to that of an ordinary person is because the consequences for the professional man are far more grave. So you can be able to see, members, that where the consequences of any professional person are more grave compared to that of an ordinary lay person. And that is basically what you need to understand about the standard of care. Remember about the standard of care. Remember about the standard of proof, where we say that it is the claimant must be able to prove is or a case on a balance of probabilities. So it's very important, members, to be able to note that where we have that part of negligence, then in this case we look at the standard of care and we look at the standard of proof. And there is also another very important case, the case of Bolitho versus City Acne Health Authority. And in this case, I did mention that where we have that expert's opinion, the body of opinion, as I said, must be responsible and reasonable. Responsible or reasonable. And where we have this body of opinion, we say that it's just a matter of practice and not law, and we say that the court will be the final arbiter in matters of negligence. It's the one which will be able to give the final pronouncement, or it will be able to pronounce itself on these matters of negligence, inasmuch as we had a responsible body of men giving that expert opinion. And then there is also an issue of like where in the medical practice we have inexperienced doctors coming in. In this case, you need to understand, inasmuch as even if a doctor or a medical practitioner is not that experienced, or does not possess so much of experience, the standard of care is still the same. The standard of care is still the same, because the expectation is that even if we have an inexperienced doctor, that doctor or that medical practitioner should be able to consult with these seniors. And therefore, in that case, a young medical practitioner or a young doctor cannot be able to say, I was negligent because I did not possess the requisite experience. That in law cannot be able to stand, because the practice is very clear, or the rules of the game are very clear, that you can be able to consult your seniors. You can be able to consult with your seniors. You can be able to ask your seniors where you have a challenge, and therefore that cannot be an excuse. So inexperience, in this case, members, cannot and will not be an excuse. And look at the case of Wiltshire versus Essex Area Health Authority. That's a very seminal case, members, which tells us that inexperience cannot be an excuse. And we also have an issue of where we have error of judgment. Sometimes a doctor or a medical practitioner may exercise an error of judgment. And members, what you need to note is that where we have this error of judgment, in this case, where a doctor or a medical practitioner exercises that error of negligence, error of judgment, then the court will be able to make a determination whether the act is negligent or not, because more often than not, we usually have this error of judgment. And even from that error of judgment, we also look at the intention of the negligent party, whether it was intended or not. And therefore, we'll be able to look at the intention, whether it was direct or it was oblique. And with that, we'll be able to make a determination whether that person was negligent or not. And you can be able to look at the case of Whitehouse versus Jordan, whereby a doctor pulled child head for too long and too hard with forceps. The child suffered brain damage, and in this case, an error of judgment was made, but the doctor was told not to be negligent. So you can be able to see it's a matter of it's a matter of practice, or it's a matter of fact whether the doctor was negligent or not. And you can be able to see that very important case, the case of Whitehouse versus Jordan, members. Then from that, you have to prove the proof of breach. That is also very key. And remember, I said where we have this the proof of breach, in this case, the claimant must prove his or her case on a balance of probability. So you can be able to see, just like another civil case, under this, because remember, negligence falls under a civil liability, or what we call tort. It can be prosecuted under tort, or it can be prosecuted under civil liability. And therefore, in this case, the standard of proof is the standard of proof basically is on a balance of probabilities. So in this case, what we are saying is that the claimant must prove his or her case on a balance of probabilities, and therefore the test is not that higher compared to those of, or compared to that of criminal cases. You need to understand, of course, you know, for criminal cases is beyond any reasonable doubt, but for negligence and for civil actions is the proof is basically on a balance of probabilities. And look at the case of Dwyer versus Roderick. The case of Dwyer versus Roderick. I've discussed about the case of Ark versus Cole, and of course you have discerned that Lord Denning said that a charge of professional man is higher compared to that of an ordinary person, and that is very well enunciated in the case of Ark versus Cole. So members, remember the case of Ark versus Cole, whereby the Lord Denning enunciated and said that a charge of negligence coming from a professional person is higher compared to that of an ordinary person. Then, still under that negligence, we also need to look at another aspect known as res ipsa loquitur. And under this res ipsa loquitur means the thing speaks for itself. And when you talk about the thing speaking for itself, is whereby you do not need to prove so much. We can be able to say your acts speak for themselves. Your missions speak for themselves. And therefore, in this case, we look at how the things were done, or how the omission, how the omission occurred, and then we can be able to conclude whether there was negligence or not. And you can be able to see, like in the case of Cassidy versus Minister of Health. And in this case, members, this is where a patient went into hospital for treatment of 2 stiff figures and came out of hospital with 4 stiff figures. So you can be able to see this patient went into that hospital with 2 stiff figures, but when he was getting out of that hospital, he was worse than he entered into that hospital. And you can be able to see from 2 stiff figures, he was able to sustain 4 stiff figures. And from that respect, members, you can be able to see that indeed there was negligence on the part of that medical practitioner or doctor who was attending to that patient, because you cannot explain how a patient who had an issue of 2 stiff fingers and getting out of the hospital with 4 stiff fingers, and therefore in that case you can be able to see the thing is speaking for itself. There is negligence on the part of that medical practitioner, and that is what we call res ispa loquitur. Then there you also are still under that. You also have the case of Brown versus Osborne, and this is where, and in most cases, doctors leaving swabs or surgical instruments in the wombs of patients, and therefore that is basically a clear case of negligence, because we have the lay down procedures on how surgeries should be undertaken. So that's also another very clear case of this this doctrine of res ispa loquitur, where we are saying that the thing speaks for itself. And then finally, members, we have the case under that res ispa loquitur, we have the case of Roy versus Minister of Health. And then we also have the case of what we call direct liabilities. And in this case, we are asking ourselves, if the doctors or the medical practitioners, being the employees of a certain hospital, who is liable where negligence occurs? And you need to understand, in such a case, because where we have employees, we have a master somewhere. And in this case, you need to understand that where the employees of a master are negligent, then in this case, more often than not, this master will also be held liable for being vicarious, or being and this happens because of that special relationship. Remember about vicarious liability, and in this case, under this vicarious liability, of course, the master will be able to take up the acts or the omissions of his or her employee, and therefore in that case, that relationship will be defined, and we'll be able to say that the first defendant will be the master and the second defendant will be that employee. And therefore in that case, members, it's very important to note that where we have such a relationship, then it's very clear that the hospitals in this case will be vicariously liable together with the employees. And look at the case of Wilshire versus Essex, and the case of Wilshire versus Essex Area Health Authority. Then finally, members, let's now look at causation and remoteness of damage. And I did discuss about this causation, and we discussed about the case of R versus Blau, that is Republic versus Blau. And in this, under causation, we need to ask ourselves just 2 questions. The first question is, what actually happened? That is one. And the second question is, what could have happened if the defendant was not negligent? So once you prove that, once you answer those questions in the affirmative, then we'll be able to know whether whether the chain of causation was broken at a point, or the chain of causation flew from point A to B without any interruption. So in this case, it's very important for you members to really appreciate where we have the chain of causation, the causal link, and whether there was any novus actors intervenience. So it's very important, members, to note on that. And then once we have the 3 tests having been satisfied, that is, remember, the duty of care, the breach, and the loss or damage. Of course, the final, where we have where we have a contention, then someone will be able to have defenses. And in this case of negligence, we have two important defenses. The first defense is what we call the contributory negligence, where both parties have contributed to that negligence. It could be apportioned. Doctor 80, patient 20, or patient 40, doctor 60. That is what we call contributory negligence. Each party contributing to that negligence. And see, look at the case of Pigeon versus Doncaster Health Authority. Pigeon versus Doncaster Health Authority. And the second illegality is about, the second defense is what we call the defense of illegality, or what we call ex turpe causa. And under this defense, the second defense of ex turpe causa, this is where a person or a defendant cannot be allowed to benefit from his criminal activities, because to do so, then it means that that person will be given all the benefits, and that person will be able to run away with that liability of that criminal liability. And therefore, in this case, we are saying that where we have, or where the defendant acts are criminal, then in that case, in as much as we may be able to reduce the charge possibly from murder to manslaughter, but we cannot, the law is very clear, we cannot be, under this defense of illegality, we cannot be able to remove the aspect of criminal liability. So that's how, members, you need to look at that, where the two defenses being very key, being very important, the defense of contributory negligence, and secondly, we are talking about the defense of illegality. And you can be able to see, like in this case, we have the case of Clanis versus Camden and Islington Health Authority. And in that case, diminished responsibility accepts that the accused person's mental responsibility is substantially impaired, but does not remove liability for his criminal act. So you can be able to see, in this case, you can be able to see there is an aspect of a charge being reduced from murder to manslaughter, but you can be able to see the criminal liability is not removed. And that is basically under under the defense of illegality, that you cannot be able to benefit from your criminal acts. So basically, members, that is what what I wanted us to discuss today. And you can be able to see it is a very important chapter, members, chapter, because it is the central of the set standards. Because we are saying what happens if the set standards are violated. Remember, we say that where these set standards are violated, then the violation attracts criminal or civil liability or disciplinary actions. And therefore, you can be able to see this medical negligence being the center or the art of the medical, being the center or the art of the good standards of medical practice within a society. And basically, members, that is all that you need to know. Maybe as you retire, please look at those cases I have highlighted to you, so that you can be able to appreciate the depth of those cases and the principles underlying those cases. And therefore, mine is to thank you so much for your participation, and just to impress upon yourself to be able to read much about this very, very important chapter. Thank you so much. Stay safe and God bless you. Asanteni.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.